There have been several instances in India in recent years of governors and elected state governments not seeing eye to eye. The role, powers, and discretion of the governor's office in multiple states have been debated for decades. Therefore, it is important to understand what the framers of the Constitution had in mind for the powers granted to the governor and lieutenant governor. The Indian nationalist movement sought various reforms from British rule, aiming for better governance. This led to the Government of India Act 1935, which came into force in 1937, aiming to bring provincial autonomy. With the 1935 law, the governor was now to act in accordance with the advice of ministers of a province legislature, but retained special responsibilities and discretionary power. Upon independence, when the Provisional Constitution of 1947 was adapted from the 1935 Act, the post of governor was retained, but the phrases "in his discretion," "acting in his discretion," and "exercising his individual judgment" were omitted. The post of the governor was extensively debated in the Constituent Assembly. Under the parliamentary and cabinet systems of governance adopted by India, the governor was envisaged to be the constitutional head of a state. The governor's powers are limited and nominal. The governor's actions, recommendations, and supervisory powers over the executive and legislative entities of a state shall be used to implement the provisions of the Constitution. The governor has to cooperate with the elected state government. Article 163 states that the Council of Ministers of a state, with the Chief Minister as the head, should aid and advise the governor in carrying out his or her functions, except in so far as he is by or under this Constitution required to exercise his functions or any of them in his discretion. The governor appoints the chief minister after an election and the council of ministers on the advice of the chief ministers. The governor can also summon, prorogue, and dissolve the legislative assembly. Every bill passed in an assembly has to be sent to the governor, after which the governor has 4 options: to assent to the bill, withhold assent, reserve the bill for the consideration of the president, or return the bill to the legislature, asking it to reconsider the bill or an aspect of it. The governor can also suggest an amendment to the bill. The legislature is supposed to consider the recommendations quickly, but if it chooses to pass the bill in the same form again, the governor shall not withhold assent therefrom. The lieutenant governor is the head of a union territory. Currently, 5 out of 8 union territories in India are headed by lieutenant governors. The rest are managed by administrators. A special provision for the National Capital Territory of Delhi was inserted in 1991. The Lieutenant Governor of Delhi also acts on the advice of the Council of Ministers, except on the subjects of police, public order, and land. The Lieutenant Governor can exercise his discretion when required by any law.